Hi, it's Mike Del Signore, Massachusetts OUI lawyer. Today's video I want to talk about a question I got from another colleague of mine about what happens if your the person has an OUI out of state. This was the call I got today. OUI in, say, New Hampshire, could be any state, Connecticut, and then an OUI in Massachusetts. But in Massachusetts, they charge it as a first offense. They offer you the 24D program. So what are the license implications in this scenario? So the benefit is if it's charged as a first offense and if a first offense plea goes through, the person won't have to take the 14-day inpatient program. So as you might know from other videos, and I've explained this a lot, if the OUI is within 10 years, the minimum penalty in Massachusetts would be, on a second offense, you have to do a 14-day inpatient program. If it's reduced or treated as a first offense, or if the DA doesn't know about it, then you can avoid the 14-day program and get the 24D program, 45-day license loss, and do an online 40-hour program. However, the registry is still going to treat this as a second offense, no matter what the court says. So in this situation, the person had taken a breathalyzer. They were looking at a 2-year license loss for the case because of the prior offense. So the 45 days that was mentioned in court was not going to be the license suspension. It's going to be 2 years. Now, the positive or the good news is that they would be eligible for a hardship license by going to the Board of Appeals. So they could probably get back on the road early with an interlock in the car. However, they're going to have an interlock for a long time. It's going to be for the period of the hardship, which will be a little less than 2 years because it's going to take some time, and then another 2 years after. So the person's going to have an interlock in the car for quite a while. And the interlock requirements can be tedious. I had a client facing the same situation. They were, the case was in Uxbridge. The DA would not reduce it to a first offense to prevent them from having to do the 14-day program. We went to trial, we won the case, so my client does not have the lengthy license loss associated with a second offense. So always the best option if you could take these cases to trial and win them. These are very winnable cases. The evidence doesn't always come in as you might think in the police report. Basically, hard work, good lawyering can a lot of times create not guilties for clients charged with OUI offenses. So keep that in mind. Keep in mind that the license losses are strict. My name is Mike Del Signore. I help people with OUI cases. My passion. I've been doing this for 20 years. Call, text me anytime, 781-686-5924.